I'm-
I'm so sorry. Are you on already?
Yeah,
It is 14 days, right, Judge?
Yeah.
It is, because we looked it up remember
Right.
the other day. It's
Right.
14, it's not
Right.
21.
no, the other rules in the civil. But let me ask you, did this one we got service? Because there's an attorney on this one too.
That one, if you look at the hearing, yeah, it's right there. On the very top one,
This one?
that one, it went out to both. So it went out to Cecilia Morales.
She's with the Heston?
Cecilia Morales is with Beltran, with Carrion Beltran,
Okay.
and Attorney Heston.
Oh, so this is semicolon.
Yeah.
I got you.
Yeah, so it's two different ones.
Okay.
That one went out.
Okay, great.
Judge, is anybody else logged on?
Not that I know, I'm on the right one, right?
Yeah, you are, because I'm logged on to it right now.
Okay.
Judge,
No.
on page, I think, 3
Uh,
of the on his the defendant's response to plaintiff's motion for summary judgment, on 3, he's just saying that plaintiff provided insufficient notice of hearing. It says in a summary judgment proceeding, the non-movement is entitled to 21 days.
Yeah, but that's the rules of civil procedure for district court.
Right. So that's what he's basing it on, though. So I mean,
Right.
well, that's one. So, okay, I just wanted to
Right.
be aware of.
Yeah, it's 14 days here though. So he got the wrong, he's quoting the wrong one.
Okay.
So we're good there.
All right, good.
Thank you though.
You're welcome to.
That's strange. Nobody's logged on. Ms. Carrion hasn't logged
Yeah,
on.
it is because I'm looking at like what I sent them and it does say 11:45. It says 11:45 and it has well, obviously that login, right? The one that that we logged on with, would imagine.
Yeah, I don't think we both. Oh, there's somebody. There she is. I'm just gonna wait a minute or two just to see if somebody else logs on.
Okay, check. Let's see who. I mean, because obviously I did send it to the attorney's email. So
Okay.
Judge, on the notice that I attached to the email, it
Uh-huh.
does say in parentheses. I put in the Mountain Standard Time on the 11:45.
Okay.
The one that I attached to them as well on the email, because I
What?
attached the notice.
Why don't we just give him a call? Can you?
Sure. Let me give him a call. I'm
Number
gonna
four?
I'm gonna mute myself.
Okay.
Judge, I'm on the line with them. Okay.
Okay.
So just to let you know, they put me on hold, okay? So I'll get back to you as soon as I hear something.
Okay. Sorry.
Hello.
I'm sorry for the wait. Ben is on the line with the defendant's counsel. I don't know if they're trying to get on or what's happening, but that's the delay.
Okay. And they never responded to the MSJ. So,
I think we have, maybe I was looking at the wrong case. Let me, one
and
second.
this is Moreno.
Claudia Sebas, no?
No, I have,
I have Claudia Acevedes.
pardon me. So that on Moreno, which was the earlier case, I had the two cases flipped. So on the earlier case, which was Moreno, they didn't respond at all to the motion for summary judgment.
Right. Yeah, we didn't have we didn't have one on file, correct. We do have a response to this one.
So let me go grab the Aceves file because I had my two cases mixed up. So I had already put that one away.
No problem.
I'll be right back. I have the cases mixed up.
Judge.
Yes.
So apparently that they thought that it was at 12:45, and then so they just said that it was their error, not ours, because the notice clearly says Mountain Standard.
Uh-huh.
So they're gonna have somebody log on apparently.
Okay. Okay.
Just to let you know.
Thank you.
You're welcome, Judge.
Ben spoke with them, and it's a problem we have sometimes is that it was noticed at 11:45.
Yes.
They didn't realize it's Mountain Standard, so they're trying to get somebody to log on.
Oh, but it would already have been, I think they're in the Dallas area, Central
Right.
Time. Okay.
So somebody's getting on now. One second, let me see. Morning.
Hello, I apologize for just now showing up, but I
No problem. Is
thought it
it
was
Gail West?
time.
Gail West, is that
Yes,
correct?
with
Yes.
Hester.
How are you doing, Ms. West?
I'm doing well.
You're ready to proceed on the motion for summary judgment? Or
this is their motion for summary judgment.
Yes,
and
uh-huh.
I'm ready for a response.
Okay. Ms.
And
Carrion?
I do want to bring up the point that we never got notice of this. We did put together a response as quickly as we could, but we never got any notice from opposing counsel that this was even set for a hearing. And we did get something from the court that said, hey, you're set and here's your information, but nothing from plaintiff. So I'm not sure about going forward at this point, or, you know, we requested based upon the lack of notice that their motion be denied, and if they want to do something, they can set a date and give us proper notice.
Well, I
Your
looked
Honor,
at your,
whether the notice,
go ahead.
whether the notice comes from us or the court, they got notice. There's no rule that requires that we provide notice. We got the same notice that they did from the court, and I don't understand that being a legal objection.
Well, Judge, it wasn't even 21 days.
21 days is not required. This is JP court.
It's 14 days, and your response was filed 9/24.
Correct. We put something together as quickly as we could when we finally found out that there was a hearing on this. So I just wanted to point that out, Judge. I'm assuming, as in most courts, that plaintiff has to send out notice of hearings and things, but
That's only when the court directs us to do that, because the court does not send notice. But in this case, the court sent notice to both attorneys of record, and we got the same notice they did. That was the same notice. And 14 days is all that's required, and we received 14 days notice.
Okay, Ms. Woods, are you referring to the notice of 9/22? Is that what you're referring to?
I believe that's the date, Judge. Yes,
Okay,
right.
that is 14 days in advance, is it not? Let me see.
It is, Judge. It's 14
Okay.
days, but just, we're a little
Okay.
blindsided by this, that it was set so quick and hadn't heard anything from opposing counsel. So we did put together a response as quickly as we could, so I do have that on file with you.
Okay, well, I mean, as long as you got 14 days notice, we're good.
Okay.
You're not disputing that, correct?
No, we did get it from the court on 9/22.
Okay, let's go ahead. Ms. Carrion?
And just so that everyone's clear, that's the same notice, the same date that we got notice. So, Your Honor, we are proceeding under our first amended motion for summary judgment. My client plaintiff is El Paso Area Teachers Federal Credit Union, who pursuant to Rule 166A is moving for summary judgment against Claudia Faye Aceves. This is a suit for $4,537.95 plus pre and post judgment interest, attorney's fees, costs of court, as shown in plaintiff's petition in this cause. Plaintiff and defendant entered into an agreement with Golden Key Federal Credit Union, who merged its assets and are now owned by El Paso Area Teachers Federal Credit Union, as described as plaintiff's petition. And defendant became obligated to pay plaintiff, as evidenced by the contract that's referenced in our motion as Exhibit A. Plaintiff performed all its obligations under the contract. Defendant defaulted in payment of the debt created by the contract, is also evidenced by Exhibit A. We are seeking $4,537.95, which is due by defendant to plaintiff under the contract. We are also seeking attorney's fees in this case, and our affidavit for attorney's fees is on file with the court. Your Honor, we have provided in our response, our supplemental motion, the contract that provided for the merger of TFCU, that Golden Key merged with TFCU. We have provided the Golden Key contract. We have provided the full payment history, which verifies the debt that is owed. We have provided the pre-suit notice correspondence to Ms. Fraye regarding the debt that was unpaid. There's several pieces of communication regarding the unpaid debt and in reference to the 2009 Toyota Corolla loan. Let me see. In addition, we have provided the verification that that these notices were sent to Ms. Fraye via certified mail. We then sent notice of our plan to sell the property and giving Ms. Fraye Aceves an opportunity to correct the breach and default. Those notices came back undeliverable. No forwarding address was left by Ms. Fraye Aceves. We then have also provided the calculation of deficiency balance for the loan. We have provided the tracking information regarding that deficiency balance. Further, we have provided the statement regarding the collateral, which was the vehicle that was repossessed, the condition it was in at the time of repossession, and the quality as referenced, that the body was poor, mechanical was poor, in general, it was in poor condition. We have further provided to you the NADA value of the collateral and the bid notes regarding the bids that were made on the vehicle. And there were a number of bids, and when a bid was accepted, the bidder would not respond to notice that their bid had been accepted. And ultimately, we provided all those bid notices to the court as part of our summary judgment evidence. And the ultimate bid that was accepted is also on file with you. In terms of the affidavit for attorney's fees, I have provided my affidavit. In this case, there was discovery that was conducted. There was supplemental discovery produced. There was an amended motion for summary judgment prepared, and all of the time spent on the case is broken down and attached to the affidavit of attorney's fees. And I am seeking $3,165 as attorney's fees as a result of all the time spent on the case. I have also prepared a response to the defendant's response to the motion for summary judgment. And if I could get into that next, that would be fine. There is.
Did we receive that? Did you send that? When did you send that to us?
That was provided on, let me look at my certificate of service, September 24th, 2020.
Okay. I don't have that in my file, so I'm not real sure.
Oh, I'm sorry. No, you have sent me your response to my motion for summary judgment, and I'd like to argue the issues that you brought up in that.
Okay, so you didn't file a response to our response.
That's correct.
Okay.
Well, there is a plaintiff supplemental response, 925. Is that?
I think
That
that
was supplemental response to the discovery, I believe, Your Honor.
Oh, so discovery. Yes, I'm sorry. Okay.
Yeah.
Okay.
And so,
Ms.
Judge,
West?
I may argue my
Yes.
my
Please.
position on this. Well, and I'm just going to go through our response mostly because it can be followed pretty easy. We're going to object to any information and any evidence that the affiant tries to make in this case. There's case law that says it has to be made on personal knowledge. I'm sorry. It's. I don't believe that she went through and demonstrated that the affiant has personal knowledge of the manner in which the records are kept or anything of that sort, which is part of the business record requirements. There is the affidavit of Ms. Stewart that has a lot of conclusions and hearsay in it, and I would object to those as evidence. Those aren't evidence. The evidence has to be derived from the documents. And there's lots of case law that anything extraneous is is not really allowed, just the authentication information on an affidavit, a business record affidavit. With regard to the condition of the vehicle, there's not really anything that supports that other than a statement by Ms. Stewart that said it was in bad condition. And I don't see where she has shown that she's an expert or has any knowledge about what a condition of a vehicle does to its value or anything of that sort. And there's nothing other than her saying that this was commercially reasonable disposition of the collateral, other than her saying that, and that's hearsay. Plus, Judge, I don't believe in the plaintiff's petition. One of the requirements is that they actually plead commercial, let's see, reasonableness of the disposition of the collateral, and that wasn't pled. So they can't even, at this point, without amending their petition, even try to bring that in now. And so those are my objections to their first of all, their statements in their affidavit, and then some of their evidence. There's not real clear. She says that Ms. Corrion says that everything shows what they did and everything that they did to try to get rid of the vehicle. Unless she can't testify, and all we have are some documents that say, hey, we got these offers. Some of the offers were as high as $4,000. And why they didn't say, okay, we'll take that, here you're obligated for your bid, and why that's not done that way, I don't think that's reasonable to just say, oh, okay, you didn't call me back or anything. So they absolutely took the lowest bid out of all of the bids for the vehicle. And so I think that goes towards the reasonableness, and I think there's a real problem with that. I think that most of that kind of covers most of what we are arguing. I don't think, based upon this, I don't think that they have proved up all the facts that are necessary, especially the fact that they didn't plead commercial reasonableness, and then they don't have sufficient information on the actual, did they auction it off, or how they went about not accepting the good offers, except, once they were received.
Okay, thank you. Ms. Carrion, would you like to respond?
Yes, thank you, Your Honor. So Ida Lee Stewart's affidavit, although there are some conclusory statements, they're not to be relied upon as conclusory statements, because all of her statements are supported by the evidence attached to the summary judgment motion. Everything that she is making representation to is supported by the records from the credit union as to the position being taken by the credit union. Your Honor, my client has been, Ida Lee Stewart has been in her position since March 18th of 2010. I believe that indicates that, as the collection supervisor and custodian of records, that she has sufficiently demonstrated her knowledge of the essential facts based on her 10 years with the credit union. There is reference, I take exception to the reference that we took the lowest bid. Efforts were made in terms of the evidence to support the condition of the vehicle. You have all the records attached to the motion for summary judgment from the repossession agent that is making reference to all the challenges that this 2009 Toyota Corolla was found to have. It references the damage, it references the condition, it references all the problems and the challenges with the vehicle, which would impact TFCU's ability to sell it for the NADA value. In terms of the bids, the asset recovery bids, the face of the bids make reference that approved bids will be called back. and the acceptance of the bid, the payer or the winning bid must provide payment within 2 days of acceptance of said bid, and that TFCU reserves the right to accept a higher bid if one comes in after the 2-day timeframe has expired. Now, the individuals bidding have 2 days to complete the transaction, and if they don't, then that bid fails. It is referenced on the face of the bid sheets and the notes. The TFCU notes make reference to the resolution of each bid, and then they go to the next bid and attempt to complete that bid process and complete that
sorry,
transaction.
I don't necessarily see that in the evidence, Judge, and so her testifying should not be.
I'm not testifying as a witness, Your Honor. I would ask you to look at each of the asset recovery bid sheets that were provided in the motion for summary judgment. And on the face of them, the information is there, and this information is pursuant to a business records affidavit, which verifies that they are the true and correct records of the credit union. And so that is my response when it comes to that objection.
Ms. West? No.
I'm just objecting of anything extraneous she's bringing in other than what's actually on that sheet. So
Okay.
her saying that they did this and that, I don't think that could be admissible evidence.
The sheets themselves make reference to what happened for each of those bids.
Are these remote sales? Is that what it is? Why they're sending by email? Is that what it is?
The vehicles are at the TFC site, and there is a website that also publishes all the vehicles. So they're subject to inspection or whatever the bidder chooses to do. But the bids are submitted, and then after so many bids are received, then they look at the highest bids and they start trying to complete the transaction based on those bids that were received.
Ms. West, anything you'd like to offer or respond to?
On the entire bit of evidence, I still say, Judge, our biggest stickler point on this is that they never pled for the reasonable. They never pled reasonableness of the disposition of the collateral, which is required under state law, and it should be in the petition as a pleading. And then, of course, I did make the objection. There are some statements about the condition of the vehicle, but we don't know who did this or how this affects the value of the vehicle whatsoever. So there's some lacking information that I don't think under a summary judgment is sufficient to allow them to get a summary judgment. And then I think other than just what you see in the bid sheets, I don't think there's anything saying that their process, how it was actually done and whether or not it was reasonable under these cases. I don't know. Normally vehicles go to auction if they're not sold at a credit union for a reasonable amount, and so that would be my argument. Other than that, Judge, I don't really have much else.
Ms. Carrion, would you like to respond to the
Your Honor,
required in the petition?
Your Honor, I don't believe that there is a requirement that is part of the petition. I think that is argument and a defensive argument that can be made that it wasn't sold in a commercially reasonable manner in an affirmative defense, but we don't have that in this case. We have an argument as to whether it was commercially reasonable or not. And based in our county and in our community, I am representing to you that when vehicles are taken to auction, that they're sold for even less than what is normally able to be received at the commercial sales that the credit union conducts. That's been the experience in this community and in this county. I don't know what is done in other counties, but that is my experience locally. But I do not believe that there is any requirement, and I don't see that that is even part of the response to the motion for summary judgment, where that objection is made as to the commercial reasonableness of the sale. That is for the court to determine based on all the evidence that is supporting the motion for summary judgment.
Ms. West?
I have nothing further, Judge. I do believe it is actually a requirement under Texas law. I was looking through my brief about this, and I can't come at that right at the exact moment, but I do believe that because I have read case law that says once that is pled, then it is up, then it all switches on who has the burden to prove it. And so I don't think that was.
Well, and we're not asking that the burden switch. We're representing to the court that the vehicle was sold under commercially reasonable manner within El Paso County, Texas.
Judge, there's some pretty hard and fast rules about determining commercial reasonableness. There's a regional finance company case, and then there's the UCC that outlines that what needs to be done to show commercial reasonableness. I'll just read them quickly. Whether the secured party endeavored to obtain the best price, whether it was sold in bulk or piecemeal. And these are things that they need to show you to be able to show reasonableness of the disposition. Whether it was private or public. Was it available for inspection before a sale? Was it at a propitious time? Whether the sale was advertised, and then where the sale was conducted and that sort of thing. So those are some requirements under the UCC that make that, and under the regional finance company case. So
Okay.
that's just, I don't believe they've met all those requirements.
And I believe we have, Your Honor. If there was a question to it, the response for summary judgment could have included it, and the response for summary judgment didn't make any mention or call into question at all any of those factors. It merely makes reference to standing and the conflict with the affidavit.
I think page 11 of our response actually talks about whether the plaintiff has enough evidence to prove the commercial reasonableness of the sale.
Well, it talks about the intent to sell. It makes complaint regarding the notices that were provided. These are public sales. The website and then the advertising are all public. It's not private sale.
Okay, I'm going to grant the motion for summary judgment. $4,537.95 and the attorney's fees of $3,165.
Thank you, Judge.
You can give me a copy. If you can give me an order, please.
Yes, and I think we forwarded it this morning. Ben did inquire about it.
Oh, I think, yes. Okay. Okay.
Thank you, Judge.
We will email you a copy as well, Ms. West. Do we have your specific email or the email on the answer, or?
I think it should be attorney at Heston Law Firm, that they will
Okay.
process it properly.
We got that. Okay. Thank you all.
All right.
Thank you.
You will be excused.
Yes, thank you.